to the June 2nd professional development course, Who's Your Seller and Other Considerations. There will be opportunities after each section to ask questions, or you can submit your questions by chat. And if you ask a question at the end of the section, please remember to unmute yourself to ask your question, and we'll proceed that way. For those of you who don't know me, I'm Kimberly Gilbert-Tell, an attorney with Raver Law Offices, practicing here in Martinsburg. So let's get started.
Can you allow us to record the session?
I believe Tammy is attempting to record it so that it can be posted on the board's YouTube channel.
Okay.
It is recording right now.
All right.
All right. So Justin, who is your seller? Our goal for this evening is for the real estate agents to have an understanding of how to ensure that you have the correct signatures on listing agreements, contracts, and other documents for real property sales, and how to ensure that the transaction closes and does not fall apart due to a lack of the proper parties or the proper procedures. Okay, some of the topics we'll cover this evening include dead people, entities, trusts, minors and other incompetent individuals, powers of attorney, bankruptcies, relocation, foreclosures and REO, the West Virginia non-resident withholding, Foreign Investment and Real Property Tax Act, 1031 exchanges, and other miscellaneous such as short sales, HAMP loans, and other matters that arise at closing. So we'll start with looking at dead people. We like to look at surviving joint tenancies, heirs, devisees, executors, and who has the authority to execute your listing agreements, contracts, deeds, etc. And just to kind of get you started, we'll throw a little humor in there. All right, we're going to start with talking about surviving joint tenants. Whenever a property was deeded to more than one individual and one or more of them have died and they owned it by joint tenancies, then there's a couple of things that need to occur in order to for the survivors to be able to pass good title to the property. First thing is that there needs to be a confirmation that the joint tenancy has not been severed prior to the death of the individual who passed away. An example of that would be if a property was conveyed to a mother, her son, and her son's wife as joint tenants. In that kind of conveyance, all three parties own an undivided 1/3 interest. Now, if the wife quit claims to her husband, her interest in the property, the tenancy, the joint tenancy has then been severed because you no longer have everybody owning an equal interest that they acquired at the same time and in the same share. So in that case, if mom passed away first, her interest would not automatically pass to her son now. Her 1/3 interest has been severed by the deed that she did not join in, and therefore her 1/3 interest would now go to her estate and have to be probated. So that's why it's important if a property was owned as joint tenancy to make sure that joint tenancy had not been severed prior to the death of the person who is no longer with us. The next item is that the death certificate of the deceased party needs to be filed in the county so that of the property, so that there is a public record of the death, and that death certificate can be examined by the abstractors to make sure it was a valid death certificate. And the reason I bring that out is because I am very aware of an instance where a pair of gentlemen were forging death certificates, using those forged death certificates to probate properties and then selling the properties out from under the owners. I actually helped with an FBI sting to catch the guys because we found one of the dead people very much alive. So that's why the death certificate is supposed to be filed in the county so it can be reviewed to ensure that it is the death certificate for the record owner. And then estates. Obviously, if the property is not owned as joint tenants, then the estate has to be probated in order to proceed with the sale of the property. It has to be filed in the county that the property is located. If the deceased party's estate was probated in another county or another state, there is still documents that need to be filed in the county in which the property is located. You also have to look at whether there is a will or whether the person died intestate. If there is a will, then the property goes to the individual or individuals set forth in the will. If it's intestate, then the property goes to the heirs in accordance with the intestate law in the jurisdiction. So then you have heirs or devisees. Under a will, if there are devisees under a will and one of them has passed away, then you also have to look at probating their estate as well. Same thing with an heirs. When you're selling the property, you have to make sure that all of the parties are in agreement. Do all of the heirs and devisees agree to sell this property? Are you going to have 4 of the 5 siblings say yes, they want to sell, and 1 who says no? In which case you've got a problem because you can't convey 100% interest in the property. Are any of the heirs or devisees deceased themselves? And in which case you there again have to probate their estate and make sure all the proper filings are in the county in which the property is located.
I have a question.
Yes.
Earlier you said if there's 3 heirs to a piece of ground and 2 wants to sell, 1 doesn't, can they transfer their interest without the 3rd signature or no?
No, they need all of the owners of the property to transfer the property. Otherwise, they can only transfer, say, a 2/3 interest.
And that's what my question is. I don't understand that. Say, just as an example, you have land that 3 people inherit. 2 want to sell, one wants to, 2 wants to sell, 1 wants to keep. Can the 2 sell 2/3 interest? And then the remaining person, that 1 person, have to share ownership with these 2 new people?
I mean, you could, but practically speaking, where are you going to find somebody who wants to share ownership with a 3rd person?
Hunting land.
Possibly. I mean, it would have to be an instance where they are fully aware that they're only receiving an undivided 2/3 interest. So it's not like I get my 1/3 of the property over here and you get your 1/3 in the middle and somebody else gets their 1/3 over on the other side. They would each have a 3rd interest in the entire property.
I understand.
So then who gets to use it when and whatnot can become contentious. So yes, you can have a conveyance of a partial interest, and I've seen them, but not very often. Because 99% of your buyers are not going to want to have to deal with this other person that they may not know, and may not be comfortable with, what roadblocks are going to be put up against their use of the property and things like that. So does that answer your question?
Yes, and inside of that answer, I would assume that if the two could find an individual willing to share ownership with an unknown person, that one person wouldn't have a choice. They just have to go along with it.
They have to go along with it, but it could get real contentious in terms of everybody trying to assert their rights. That one person may presume that they have superior rights and try and assert them that way, and the other two individuals would have to, it would be incumbent upon them to realize that that might be the situation.
Okay, thank you.
Okay. And then also with regard to estates, there are some instances where the will directs that an executor or an administrator sell the property and divide the proceeds rather than have the property go to the heirs or devisees. So in that case, you would have to, again, be looking at the will and determining who has the interest and the authority to sell the property. And then you also have to look for, especially with wills, for property-specific provisions. Does the will create a life estate in the wife and then give the property to the kids? Does the will create timber rights in somebody else? Does the will, so you have to look specifically at the will to see what it says about your particular property, because some wills designate particular properties, to be encumbered by certain obligations, to go to certain people, to have life estates in other people. So it is very critical that the will be reviewed carefully to ensure that not only do you know who the heirs and devisees or executors and administrators are, but to ensure that all of the property rights with regard to your specific property are identified and addressed. Any other questions? Okay. Then we're going to move on to entities. Entities are fun. And in many cases, the principals of the entities are not aware themselves of the documentation they're going to need to establish that the individual signing the deeds and other documents has the authority to do so. So we're going to take a look at a couple of entities and kind of go through them and identify the different documents and why they're necessary. So we'll start with limited liability companies because that's the type of entity we run across quite frequently in titles, because they're so easy to organize and they give the principals the benefit of a partnership agreement in terms of the way that it operates, but the benefit of the liability coverage of a corporation with regard to risk and liability. So the first thing you need within a limited liability company is what they call articles of organization. That is the basic document that is filed that says, this is our name, This is our principal office. These are the individuals who are entitled to receive service on behalf of the entity, and that has to be filed with the West Virginia Secretary of State's office or the other Secretary of State or other similar office in the state in which the limited liability company was formed. And then you go from there and you have to determine whether or not it's a sole member or not. If it is a sole member limited liability company, then you usually do not have an operating agreement or other type of agreement that sets forth the powers and the obligations of the different members, because you only have one member. If you have more than one member, you either need an operating agreement which sets out who has the authority to sign and sell property on behalf of the limited liability company. Is it a managing member? Is it two managing members? You know, the operating agreement will set forth the authorities and the obligations of the different members. And that has to be examined carefully to make sure that you have all of the necessary members signing your documents in order to bind the limited liability company. In the absence of an operating agreement, we would have to require that all members join. Because if you don't have a document that they have all signed saying, you know, member A can bind us as the managing member, then they would all have to join in the deed and other documents at closing. Another thing that you're going to need is a certificate of good standing. If the limited liability is not in good standing, both in the state in which it was formed, then it does not have the authority to act unless it is acting in connection with what they call a dissolution. If it is filed articles of dissolution where it is going away and selling all of its assets, then those articles of dissolution would indicate who has the authority to sign and the fact that it is in connection with a dissolution of the limited liability company. Otherwise, it does need to be in good standing to have the authority to act. We also need a roster of members who are the current members of the limited liability company. And just in case anybody ever wondered, if you have a multi-member limited liability company or one with two members, a single member cannot sign and file something that is binding saying they are the sole member. If it was originally created as a multi-member limited liability company, then if a member leaves it, that member who is leaving the limited liability company must execute the amended operating agreement or articles stating that they are no longer a member. Okay, any questions with regard to limited liability companies?
I do have a question, Kim.
Yes.
So let's say hypothetically an LLC owns a property for in excess, there's several members, let's say, and
Okay.
they own property in excess of 20, 25 years.
Okay.
The property surrounding this limited liability property has been developed and an HOA has been formed.
Okay.
If the limited liability company decides to sell the property, and they have never been contacted or informed that there is an HOA with yearly payment, how does that reflect upon the selling of the property?
If the limited liability company owned the property at the time of the development and did not join in the creation of the homeowners association, and there was no recorded covenants on the property, then it is probable that the property is not subject to the HOA.
Okay.
That would be something where obviously a more thorough investigation of the land records would have to be undertaken to confirm that.
Yeah. Okay.
But it's, unless the property was already subject to the covenants that created an HOA, even if the HOA was created afterwards, it may not be subject to the HOA.
Okay. All right.
If
It's
it is subject to the HOA, there are limitations on how many years back the HOA can go and collect dues.
okay. All right. Interesting. Okay. Thank you. That answers my question. That's the only one I had. Oh, no, wait, I do have another one.
Yes,
So in the event that one of the members of the LLC has died and the LLC, then the remaining members actually now become the owners, so I don't know what I want to say. So that it's written so that if any one member or multiple members dies, it conveys to the remaining living members of the LLC.
right. Okay,
Okay.
if that was a provision of your operating agreement.
Okay. All right. So, okay. All right. Thank
Yeah,
you.
the operating agreement would control what happens if a member dies.
Okay. All right. Good. Thank you.
If there is no operating agreement, then that member's interest actually goes into their estate,
Okay.
which can get real messy.
Yeah. Yeah. No doubt it could. Yeah. All right. Thanks. That answers my question. I appreciate it.
Okay, any others?
Yes, Kim, can you hear me?
Yes.
Member managed LLCs, how many members can actually be managers? Let's just say, for instance, if you had three, can there be three managing members where one at any given time can make a decision?
Yes, if, depending on the terms of the operating agreement can name 1, 2, 3, as many as they want, and it can specify that each member has the authority to bind the LLC, so that a third party dealing with that managing member does not have to go back to the other managing members or the other members to confirm the authority. If it's in the operating agreement written that way, you can have multiple managing members, each who has the authority to bind the LLC.
That answered my question. And also, you could also put in the operating agreement perhaps limitations on what they would have that authority to make a decision on without the others, correct?
That is correct. I have seen operating agreements that stipulate that, sale of property has to be agreed by all members at a meeting, in which case we get a certification of the resolution and whatnot. So yes, the operating agreement can also limit the authority of the members under certain circumstances to act. That is why if there is an operating agreement, your settlement attorney is going to need the entire thing to review it, to make sure not only is their powers set forth in certain provisions, but also to ensure whether or not there are limiting provisions of the operating agreement as well.
All right, thank you.
Any other questions on limited liability companies before we move to corporations? Okay. Corporations are obviously the old school entity that used to be the standard before limited liability companies became an option. Corporations require articles of incorporation, which has similar information to the articles of organization that a limited liability company would file. And that also must be filed with the Secretary of State's office in the jurisdiction in which the corporation is formed. A corporation will also have either bylaws or a constitution. And it depends on the type of corporation and the preference of the attorney who helped them create it as to which one of those two documents you're going to get. But just like an operating agreement, the bylaws or the constitution would set forth the authority of the different officers of the corporation to act and bind the corporation. It can contain limiting provisions with regard to requiring a board meeting or a meeting of the members or things like that in order to sell real property. If you're dealing with a corporate entity that is also a church, frequently their constitutions also require consent of the members of the congregation or things like that in order to act. So there again, that is those documents, either the bylaws or the constitution, would would require careful review by the settlement attorney to ensure that all of the proper parties are signing the documents. A lot of people think that, okay, if it's a corporation, the president can sign and you're good. Not necessarily. I knew one corporation that had a limiting provision in its bylaws that required the sale of any property over a certain dollar amount to be executed by not just the president, but also the secretary and the treasurer. So there again, in order to ensure that you have a good binding listing agreement, good binding deeds, and are selling, that the individuals executing the documents have the authority to sell, you do need to have your settlement attorney carefully review those documents. And also, just like with limited liability companies, corporations are also going to need to provide a certificate of good standing in the state in which they were formed. And they're going to need to provide a roster of officers and directors that lists, who's on their board of directors or board of trustees, if it's a constitution and they have a board of trustees instead, and who their officers are by name, so that the offices that are granted the authority in the bylaws or constitutions can be matched with the names of the individuals who are going to be signing. Any questions on corporations?
Kim, I think there's a question in the chat that says in West Virginia, HOA needs 100% approval from all residents to be formed.
The HOA cannot bind or include any property that is not agreed to. Now, I have 99.9% of the developers create the covenants before they sell the first lot. And in those covenants, it provides for the creation of a homeowners association to which all lots are subject. Now, I have seen, not in Berkeley County, thank you, or the Eastern Panhandle, but I have seen a subdivision that was created without a homeowners association and without a written covenant requiring payment for the maintenance of a road, and only those lots who signed on can be held to that provision for the homeowners association and the payments of the dues or assessments. The developer in that case did create covenants that he recorded against the entire project before selling the first lot, but he did not create a homeowners association or a maintenance obligation or assessment. So the only ones that were bound by a maintenance obligation or assessment or a later created homeowners association were those who signed on and agreed to be bound. I also see a question about 100% to make changes. Once the covenants and bylaws are recorded, they normally provide a means of amendment. And whatever means of amendment are set forth in the covenant would control. So if your covenants provide that you have to have 2/3 of the homeowners agree to an amendment in order to change something in the covenants, then that would be the standard rather than 100%. Most covenants and homeowners agreements also stipulate some authority for a board of directors to increase dues, but not all. And there again, if your dues are specified in recorded covenants and there needs to be an increase or a special assessment, then that would be considered an amendment to the covenants if there aren't other provisions. And it would be, it would have to be amended in accordance with whatever requirements were set forth for amendment of covenants. Does that answer the questions with regard to homeowners dues? Okay, seeing no more, we'll continue on. Just a little humor thrown in there. Corporate leadership, form a committee. Yes. Okay, couple of other kinds of entities. You have general partnerships. Now, general partnerships do not have to have documents filed with the Secretary of State's office. They are controlled by a partnership agreement. They come into being whenever the partners sign the agreement. And just like the other entities, the limited liability company and the corporation, we would need a copy of the agreement. Your settlement attorney would need a copy of the agreement to review it carefully to determine who has the authority to sign for a general partnership. I mean, sometimes it can, like a limited liability company, it can specify that all of them have to sign. A managing general partner may be able to sign, or more than one. And regardless, that would there again be something where the agreement itself is going to control who has to sign and what authority and limits on the authority there are. And we would also need a roster of the general partners in order to be able to ascertain, you know, who's actually going to be signing our documents and your listing agreement in order to bind the general partnership. Limited partner is almost identical, except that with a limited partnership agreement, you have to have at least one general partner, but all of the other partners are normally in it for the money. They put their money in, they get their return on their investment, but they don't have decision-making authority when it comes to the partnership. They also, as a result of the fact that they don't have decision-making authority, they also don't have the same liability that a general partner would. So they're on a limited partnership. If there is a loss that is experienced by the partnership, a limited partner's obligation to cover the loss is only to the extent of his original investment. So he doesn't have to pay out of pocket any more than he already has in order to cover losses of a limited partnership. That would be the obligation of the general partners. And there again, we would need to carefully review the agreement, and we would need a roster of all of the general partners. Not necessarily the limited partners, because they don't have any authority or obligation when it comes to conveying the property and handling of the proceeds. That would be all the obligation and authority of the general partners. Okay. Any other questions about entities? Okay. Moving on then. Trusts. Our lovely trusts. There are probably as many different types of trusts as there are lawyers who can think of a different type of trust. In any case with any trust, we are going to need the trust agreement to review it for validity, because there are certain components of a trust that if a trust is missing one of those components, it is not a valid trust. And what I actually had a trust that we had a major issue with because it was missing a beneficiary. And a trust has to have a named beneficiary to be valid. Okay, the trust agreement will also set forth the names or identities and powers of the trustee or trustees. A trust can call for co-trustees. It can provide that all co-trustees must join, or it can provide that any one of them may act individually. So there again, just like with your entity documents, a careful review of a trust agreement is necessary in order to ensure that you have the proper powers, etc., of the individuals who are going to be signing the documents. And you also have to look into limitations and whether or not the powers of the trustees are limited, and whether or not the prerequisite requirements have been met before you proceed with a closing for a property that is titled in a trust. So those that is an area that failure to carefully review can create a lot of headaches for the buyer in the future if the trust agreement is not properly interpreted and the proper parties signing with the prerequisites or requirements having been met. Okay. Then we get to minors and incompetent individuals. When we're talking about incompetent persons, you can have two types. You can have somebody who is temporarily incompetent or somebody who is permanently incompetent. An example of somebody who is temporarily incompetent would be somebody who was involved in a car accident or got an illness or something and is not currently able to manage their affairs and to know what's going on and to be competent to proceed. Permanently incompetent would be like somebody with Alzheimer's or other conditions, or possibly somebody who is intellectually disabled to the extent where they have been deemed incompetent to manage their own affairs. So those would be two types of temporarily versus permanently incompetent individuals. And also minors. Minors are presumed to be incompetent until they reach the age of 18 unless they've been emancipated. So there are several options to handle property that is titled in one or more incompetent individuals. If a property is being acquired for somebody, then it can be titled in a trust rather than in the individual's personal name, so that the trustee would have the authority to administer the property on behalf of and to the benefit of the incompetent individual, who would then be named as a beneficiary to the trust. You could also have a property titled in a custodian. So like, especially with a minor, if you want to title it in dad as custodian for child, that identifies the person who has then the authority to execute documents, convey the property, etc., on behalf of the child for the child's benefit. If the property was not put in a trust or a custodial format at the time it was acquired, then you have to look at guardianships, conservatorships, guardians ad litem, which means you're talking about court cases, getting court orders, having the court appoint individuals with the authority to manage, convey, mortgage the property on behalf of the child. And in those cases, obviously you're talking about time, you're talking about money on the seller's behalf, because they have to pay to get those court orders, you know, to file the motions, get the court orders issued and whatnot. And in most cases, the court is also going to want to see copies of the contract and have that filed, so that not only is an individual appointed, but the authority to go to closing and sign the documents necessary to accomplish the contract is also granted. So in that case, if your settlement attorney is not going to handle the guardianship or conservatorship on their own, they would need to work with the attorney who is handling that closely to ensure that the settlement attorney obtains the necessary documentation to show who has the authority and exactly what authority they do have. So that can be time-consuming, a major headache for the seller, and a major expense for the seller. Now, I put down the option of powers of attorney. Powers of attorney, when you're talking about a minor, are not an option, but for the incompetent, it would depend on whether it's temporarily or permanently incompetent individual and where in the timeline the power of attorney was signed. So let's look at a little more carefully at minors on title. Like I said, I've recently had a case where an individual did their own deed, and it went from grandfather to father and his son, and his son was 9 years old. So, and of course, they filed all the paperwork and were moving forward with getting all of the court orders necessarily appointed, and then COVID-19 happened and that got delayed. So we ended up settling probably about 4 months after we got the order because of the delays in getting the guardian ad litems appointed and getting the proper orders approving the sale of the property. If you know of somebody who's saying, well, I wasn't going to put my son on title or my daughter or my child, do them a favor and ask whether or not that child is 18 or over. And if not, suggest that they consult with an attorney before they do a deed putting a minor on title. I do want to go back to the incompetent individuals for just a minute. With regard to, powers of attorney and temporarily versus permanently incompetent. If a power of attorney was signed prior to the incompetence of the individual, as long as that individual is still alive, the power of attorney can be used, provided it does not contain any limiting provisions and is a durable power of attorney. Once the individual, once somebody files something in court asking that an individual be declared incompetent and a guardian or conservator appointed, then any power of attorney executed after that time would be deemed to be invalid, because you can't claim that somebody is incompetent and then say, oh, well, they changed their mind, they're going to sign the power of attorney, so now they're competent. Can't have it both ways. So, with a incompetent individual, you have to really look at a timeline on the document. Now, when I talk about temporarily incompetent, I have had a seller who was in a nursing home being treated for cancer, and she had about a half-hour window between when her pain meds were wearing off and when she got her next dose that a doctor would certify her competent. So by knowing that, we were able to make an appointment, go in, get the doctor to sign an affidavit of competence, and have her sign her deed and her power of attorney while she was competent in that half-hour window. So, there are a lot of different circumstances. If there is any doubt about the competence of a party to the transaction, it's best to talk to your settlement attorney right away so that arrangements can be made, investigations can be made, and the proper documents that need to be provided are available at the time of settlement to prevent a delay in closing. Okay. Any questions on incompetence, minors, guardianships, things like that? Okay. Now we're coming to an area that generates a whole lot of title insurance claims. So this is an area that I'm probably going to spend a little bit of time talking about, is powers of attorney. Generally, title insurance companies hate to see powers of attorney. Therefore, they have all given us this laundry list of things we have to review to ensure that it is a good, valid power of attorney, and not fraudulent, not a forgery, and not somebody acting outside of their scope of authority. So the first questions we're going to ask is, why do we need to use a power of attorney? Why is the principal not available for closing? And depending, and we also, assuming we get past that hurdle, is the principal available to verify the power of attorney? We want to be able to call the individual, talk to them, make sure they understood that they signed a power of attorney, make sure they know who they gave the power of attorney to, make sure they understand that their house is being sold or mortgaged with a power of attorney. To just make sure that they are aware that they have not revoked the power of attorney, and that the attorney, in fact, still has the authority to act. And there again, just like with that we were discussing before, we also want to look at the competence of the principal at the time they signed the power of attorney. Okay, were they competent when they signed it? If they are not competent now, is the power of attorney contain provisions saying that it survives their incompetence? Does the attorney in fact still have the authority to act even if the principal is no longer competent? We also need to look and see if there are limitations to the powers of attorney. One of the things that I have seen is a quitclaim deed signed by the attorney in fact conveying the property to themselves for no consideration. I can tell you that that is going to be presumed to be invalid unless there is a specific provision in the power of attorney allowing the attorney in fact to gift property to him or herself. But we also want to look at the power of attorney to make sure there are no other limitations. There was one power of attorney that was only valid if the principal was out of the country. I had another power of attorney that was only valid if the principal was incompetent. And if you have something like that, a limitation on a power of attorney to that effect, then you have to look at, obtaining proper verification and documentation that that restriction has been met and that the power of attorney is good. I see a question of what's the difference between a power of attorney and an attorney in fact. The power of attorney is actually the document that is signed by the principal or the person who is granting it. The attorney in fact is the individual to whom the powers have been given. So the power of attorney is the document. And the attorney in fact is the person who is going to be signing on behalf of the principal. And there is also a question as to whether an agent should allow themselves to be appointed powers of attorney or attorneys in fact. The first place you should ask that question is your broker, because some brokers have policies with regard to the fact that they do not want their agents acting as attorney in facts for the clients. I personally do not see a problem with you acting as attorney in fact, provided you get the proper confirmations and verifications from your clients. A lot of times, if I'm acting as attorney in fact, I will send the client the documents that I'm going to be signing on their behalf and have them, send them back to me or email me back saying, yes, everything's fine. They've reviewed it, it's all fine. If they can e-sign it, I'll have them e-sign it and send it back. Just so that I have something in my file that shows that they were aware of the documents, especially the settlement statement, that they knew what the numbers were, and that they gave you authorization to sign the documents. So, that's one of the ways that if your broker allows you as an agent to be an attorney in fact, that's one of the ways that you can ensure that you're acting for the principal and that they have agreed to the documents and the figures that you're signing on their behalf. Okay. Another thing is obviously, just like with every other document, your settlement attorney is going to need a copy of the power of attorney and the other circumstances and questions answered so that they can underwrite that power of attorney to make sure it's valid, to make sure the attorney in fact has the authority and doesn't need to meet any other requirements in order to have the authority to either mortgage or sell the property. And then the last thing is what they call an alive and well affidavit. At the time of signing, the attorney in fact is going to be asked to verify that to the best of their knowledge, the principal has not died, because a power of attorney dies with the principal. Once a principal is deceased, the attorney in fact no longer has any authority under the power of attorney. The second thing is that they're going to have to certify that to the best of their knowledge and belief, the principal has not revoked the power of attorney or amended it. If there is an amendment to the power of attorney, then that amendment will also need to be provided to the settlement attorney for review and consideration. And, you know, if your sellers or buyers are going to, you know, indicate that they might want to use a power of attorney, these underwriting requirements and whatnot, and all of these hoops that we jump through are for the protection of the principal. Yeah, we're not doing it just because we want to aggravate them or because, you know, we get our jollies out of paperwork. I have seen valid powers of attorney misused. And in one case, if the settlement attorney had verified, it wasn't a case I did, we got the next transaction down on the line. If the settlement attorney had verified with the principal that that power of attorney was still valid and that the attorney in fact was going to be signing documents to sell the house, the transaction that was executed with the power of attorney would never have gone through. A young man had power of attorney for his grandmother and literally sold her house out from under her while she was still living in it. And she had no idea. So that created a major issue because there was then court case, you know, to overturn the deed. So the poor buyers didn't have a house. The poor grandma was fighting, having to pay attorney's fees to fight to stay in her house. So we do these things to help protect the principal and to make sure that the principal is aware of what's going on. And even elderly principals who, you know, are no longer physically able to get out or sign documents, or who have provided powers of attorney as a disabled individual, frequently can still verify that power of attorney and make sure that they understand what's going on. So, you know, when we start asking questions and want to verify stuff, it is to protect the principal and the seller to make sure that a power of attorney is not being misused and their interest in the property is not being fraudulently taken from them. Okay. Any questions on powers of attorney? Okay, seeing none, we'll continue with bankruptcies. Bankruptcies come in three main forms. You have a Chapter 11 or a Chapter 13, which is a reorganization for a corporation or an individual. In those cases, you know, your medical bills got away from you, you're filing a bankruptcy, you're going to retain your property, you intend to continue making payments, or maybe you're going to retain your principal residence but sell your investment property to help pay off your bills, or whatever the case may be. You file a bankruptcy, and then a Chapter 7 is a liquidation, where you say, I don't have enough assets to pay everybody. I'm going to liquidate everything I have. Everybody gets whatever piece of it they have. Even under a Chapter 7, there is still exempt property. So your principal residence could be considered an exempt property. and things like that, and a certain portion of equity in your principal residence can be considered exempt, as well as, you know, your household furnishings and whatnot. But anytime there is a bankruptcy, then there needs to be a court order in order to proceed with either a sale or a refinance or a mortgage on the property. There are several different types of court orders that can be obtained. One is an approval of the sale, where you file, you know, the bankruptcy attorney will file a copy of the contract, a draft settlement sheet showing the proposed net to the seller, how much each lender with the security interest in the property, like a mortgage holder or a lien holder, you know, judgment holder, would get at the end of the sale, and whether or not there are any proceeds at the end to go back into the bankruptcy estate to pay other creditors. And that approval, you know, that submission would ultimately lead to a court order. You would need to, in the motion for an approval of the sale, you would need to stipulate costs that were going to be paid, for instance, realtor commissions. Got to make sure the realtor commissions are in there correctly. Any closing costs that the seller is paying on behalf of the buyer, any home warranties, termite inspections, any inspections that the seller is paying on behalf of the buyer would need to be included in that motion, so that, and on that draft settlement statement, so that once you get the court order, all of those things can be paid out of the proceeds. The court order would also stipulate who is going to sign on behalf of, at the time of settlement, whether it's going to be the bankruptcy trustee or whether it's going to be the seller as a debtor in possession. So the order would also stipulate who's signing and where any net proceeds go. Another type of order would be an abandonment of the property. If the property has no equity in it whatsoever, it can be abandoned, and therefore remove, that property can be removed from the bankruptcy once an order of abandonment is issued. And basically an order of abandonment puts the authority back on the seller to dispose of his property. Okay? And as I pointed out previously, the approval of the sale or the abandonment of the property would be contingent upon an execution by the debtor and the trustee. All right, any questions on bankruptcies? That's just a real brief on bankruptcies, just to give you an idea of, you know, if you have, or your settlement attorney, you know, says, oh, by the way, so-and-so's in bankruptcy, we need something. This is kind of an idea of why. And it doesn't matter where the bankruptcy is filed, it still impacts a property anywhere in the US. So if the person lives in Maryland or lived in Maryland at the time, filed their bankruptcy in Maryland, and own a West Virginia property that they're trying to sell, that Maryland bankruptcy still controls the disposition of the West Virginia property. So it doesn't matter where, an individual filed the bankruptcy, it still impacts your property in West Virginia. Any other questions about bankruptcy? Okay, we'll move on to relocation. I don't know if any of you have ever worked with a contract that where a relocation company has been involved on one side or the other. For purposes of this presentation, I'm going to talk about when a relocation company is involved on the seller side. All right. If a seller is being relocated, the transaction can be structured as either a 1-deed or a 2-deed transaction. In a 2-deed transaction, the relocation company actually takes title to the property from the record owner and then records that title. So when they buy the seller out, they're going to record the title into the relocation company from the seller. Most relocation transactions, however, are a 1-deed transaction where the relocation company gets the seller to sign a deed and all the title affidavits and everything, and holds them, basically holds them until the property is outsold. And then at that time that the property is outsold, that deed in blank will be filled in with the third-party buyer's information and provided at closing to be recorded. Even if it's a 1-deed transaction, the relocation company is still going to acquire the property from and pay the record owner for the property prior to the third-party closing. Now, it might be just an hour prior, but it's going to be prior to the third-party closing. When you're drafting a contract for a relocation company transaction, the seller will almost always be the relocation company itself. There are a few that are called direct reimbursements where the record owner is actually the seller of the property, and then the relocation company reimburses the seller his costs after the transaction closes. But very few of them are direct reimbursement sellers. Most of them, the relocation company acquires the property so that the individual being relocated has the cash available to go buy a new property in the area where he's being moved to. Also in a relocation contract, the seller's closing cost help will need to be clearly stipulated. Most relocation companies have an addendum that specifies that the buyer has a certain period of time to do all of these inspections and provide the relocation company with any repairs that they're requesting within a specified period of time. In most cases, the relocation company will have already done its own inspection and will have already obtained a disclosure from the record owner that they will frequently make a part of the contract. It would be very advisable for a buyer, if you're representing the buyer, to read those inspection results and disclosures carefully, because once that contract is signed, then a relocation company is not apt to do any repairs of items that were brought up on the inspection that the buyer already had at the time of contract, because they require the property to be sold as is. So it would be advisable for the buyer to either really carefully review those inspection results or to make provisions to have their own inspector come in. But the inspections that are already provided are part of that as-is condition of the property. The contract would also need to specify if the seller is providing a home warranty and the maximum amount of the warranty that the seller is going to pay. If it's not in the contract, seller won't pay for it normally. There's also, in most relocation addendums, a designation of the closing attorney. If the buyer wants to use their own closing attorney, please cross it out, do a separate addendum, do something to ensure that the contract stipulates who the closing attorney is going to be for the buyer, because our instructions are to not release information and documentation to another attorney if we've been named as the closing attorney in the addendum. So that's something that, I mean, it's not something where we're trying to be difficult, but it's something that the relocation companies require of us. And therefore, if your buyer wants to use another closing attorney other than the one designated in the addendum, please be sure that that is addressed at the time of contract. Once you're under contract, the actual seller is not going to sign any addenda, any disclosures, any affidavits for that transaction unless it's a direct reimbursement. So in 90% of the cases where your seller is the actual relocation company, the record owner is not going to participate in the third-party sale transaction. And that is because the way that the relocation rules are set up through IRS, if the record owner participates in that third-party transaction, it can destroy the exemptions that have been created for relocations and impose upon the record owner a much higher tax liability than they were anticipating. So that is one of those areas where, because some relocated individuals haven't owned their property for 2 years, or whatever fits in the normal IRS code, there has been a specific exemption or set of exemptions created for relocation transactions. And that is why the record owner will not participate in the third-party transaction. It all has to go through the relocation company, which gets us to our next item, repair procedures. That makes repair procedures and repair, taking care of repairs of any items brought up on home inspections or appraisals a little bit more time consuming than if you could deal with the record owner directly. In most cases, the listing agent has to get a certain number of estimates. Those estimates have to be sent up to the relocation company for approval, where they're reviewed. In many cases, that approval has to go from the relocation company to the record owner and back again before it goes down. And then frequently the contractors, the designated contractor will have to complete the work and issue an invoice before you can go to closing. There are instances where a relocation company will consider a seller credit in lieu of repairs. If you're going to go that route with your buyer, if your buyer wants to just, get the closing done and not wait for the relocation company's approval process and contractors to complete the work, work with your lender to make sure that a seller credit in lieu of repairs is properly worded so that if your lender is not going to allow a credit in lieu of repairs, that you designate it properly as closing help or prepaids, or whatever it is you need to do to designate. I have also seen instances where the seller agrees to pay a specified amount to a buyer selected contractor, so that the buyer selected contractor can then go ahead and complete the repairs. So that is another option that I have seen work. In the event, whether the repair is done by the relocation company's contractors or by way of a seller credit, most relocation companies have some kind of a release agreement that the buyer is going to have to sign saying that, you know, whatever repairs were requested are completed to the buyer's satisfaction, or that the buyer accepts the credit in lieu of the repairs and releases the seller from any further obligation for those repairs. I see a note that, another option that has been used by Rick was having the sales price reduced in lieu of repairs. And that would also be another thing that, you know, would probably be okay with a lender, because you're taking into account the condition as in terms of a an adjustment to the sales price to reflect the condition as is. Okay, so, but relocation transactions, and the other challenge with relocation transactions is that the relocation company also has its schedule and timeframes. We represent a number of relocation companies with transactions, and I have one relocation company that only needs its settlement statement 2 business days in advance, and I have another one that wants it 7. So work with the relocation company attorney, whether they're doing the settlement or whether another law firm is doing the settlement, to make sure that you understand what the relocation company's requirements are in terms of timelines, so that you don't end up with a lender giving you 2 days notice and the relocation company requires 5. So, it's a good thing to keep in contact and work closely with the relocation company's attorney as well, to make sure that there is an understanding of what those timelines and requirements are, so that we're not having to delay a closing because we didn't meet a timeline. And some relocation companies are more flexible than others about their timelines and their requirements. So that's all, part of the package that we have to look at. And scheduling closing is especially critical in that matter, because relocation companies assume that it's going to close on the closing date specified in the contract. And they do all of their planning from that date. They backdate everything from that date. So if it says we're going to close on June 30th, and they give their attorney instructions in a deed package 2 weeks ahead, that means I'm not going to get the instructions and deed package until maybe June 15th. If you want to close on the 16th, and I don't know about it far enough in advance, then we're probably not going to be able to close on the 16th, because I'm not going to have what I need from the relocation company at that point. So even regardless of what your settlement date is on your contract, just keep in mind that relocation's mindset is that that is the settlement date, unless you advise far enough in advance that we can move the settlement date up. The same thing goes with a delay in closing. If you know there's going to be a delay in closing because the appraisal didn't come back in time, or the appraisal came back in low, and you've got to go back and reappraise or renegotiate or something like that, whatever the reason, make sure that you keep the relocation attorney in the loop as well, so that we can go back to our client and get what we need when we need it to be able to facilitate a smooth and timely closing. Anybody have any questions on relocation? Oh, one other thing I did want to mention, a couple other things. Obviously, we just talked about closing turnaround times, also walkthrough issues. It would be advisable to do the walkthrough the day before closing, so that if anything comes up, we've got enough time to try and deal with it and still have the closing go off as scheduled. Whenever we get notified of an issue, we have to advise our relocation contact, and the listing agent has to advise their relocation contact, because 90% of the time it's two different people and they each have different authority. Also, with the walkthroughs and whatnot, if you have a buyer who wants to wait until after the walkthrough before they get their funds, just keep in mind that most relocation companies have a requirement that the wire of their proceeds be initiated before the buyer can have keys. Because we've had too many of them gotten burned by giving the buyer the keys as soon as they finish signing. Something happens, their funds aren't sent, and then they have a buyer living in the record owner's property. So it can get real messy real fast. So that's one of the things that you're going to want to work with your buyer if they're buying a relocation property. The other thing is possession. 99% of the time, a relocation company will not allow a buyer to take possession of the property pre-settlement. It is almost always at closing, and that's because of the relationship between and the responsibilities that the relocation company has to the record owner. So the relocation company has to protect the interests of the record owner and don't have as much wiggle room to say, yeah, you can move your stuff into the garage, or yeah, you can go ahead and move in, even though settlement had to be pushed back for XYZ. So I have only seen one case where the property was possessed by the buyer prior to closing, and that is because the buyer was the daughter and son-in-law of the record owner, and they already lived in the property before the record owner got relocated. So they were basically, buying her dad out so that they could continue to live in the property that they had lived in with dad. But for the most part, relocation companies are not going to allow keys to change hands until the closing is done and the proceeds wired. Any other questions on relocations? Okay, now comes a fun one. Foreclosures and REOs. Okay. There you go. There's your foreclosure sale sign on the beach. Foreclosures, one of the critical things is going to be the settlement attorney is going to need to do a careful examination of the title to confirm the validity of the foreclosure. Now, you would think that all foreclosures would be good and valid, but I can guarantee you that it doesn't always happen. I had an instance where the owner filed bankruptcy in another state. The foreclosure attorney did not find it and foreclosed on the property while the owner was in bankruptcy without getting any of the court orders required in order to validly foreclose on a property when the owner was in bankruptcy. I also had another instance where the owner of the property had 3 different mortgages on the property with the same bank, and the bank, in their motions, when they filed for the foreclosure, when they got the bankruptcy court order to foreclose, put the wrong recitation for the wrong deed of trust on their bankruptcy paperwork. So they ended up foreclosing on the second mortgage, not the first. Or they had the authority to foreclose on the second mortgage, but they foreclosed on the first. So foreclosures are not always done correctly. So you want to give your settlement attorney time to, do a thorough title search and examination to make sure that the foreclosure was validly conducted and that the trustees or the bank has good title to the property. Then you also need to be aware that the settlement attorney is going to need time to confirm the authority of the individual who will actually be signing the deed and other documents at settlement. If you have Fannie Mae or Freddie Mac as your seller, or if you have, XYZ servicer on behalf of ABC lender pursuant to a power of attorney, and that power of attorney is not recorded or not provided, that can create issues as well. So your settlement attorney is going to need time to confirm the authority of the individual signing the documents to make sure that they are conveying good title and that the proper parties are signing the deed and other settlement documents. And then contracting, repairing, closing, possession considerations are usually very similar to a relocation, unless your buyer is buying at the foreclosure sale. In that case, the possession may be the buyer's responsibility. And that would have to be additional conversations with your settlement attorney to make sure that the buyer proceeds in such a manner as to render the title insurable once they go to closing on the foreclosure. Okay, now we're going to talk about the wonderful non-resident withholding. Okay, there's some exemptions. The first and most obvious is if the seller is a state of West Virginia resident. Second is if the seller is a state of West Virginia entity. Okay, now with the entity, it's a state of West Virginia entity if they have filed with the West Virginia Secretary of State's office and are in good standing. Now, even if it's an outside LLC or corporation, even if it was formed in Maryland or Virginia or Pennsylvania, as long as they filed with the West Virginia Secretary of State's office and are in good standing, they are considered a West Virginia entity for the purposes of non-resident withholding exemptions. They have to be in good standing, but unlike other states, there is no seasoning requirement. Maryland, for instance, requires that the entity have been filed for at least 90 days before they go under contract with the property. In West Virginia, as long as your entity is filed by the time we go to closing, then they are considered a West Virginia entity. So there is no requirement that they have filed so many days in advance of closing. Okay. Another exemption is if it is their principal residence under the Internal Revenue Code. And if somebody asks you that, my standard answer is that is a question for your CPA or tax attorney. I cannot tell you whether or not this was your principal residence under the Internal Revenue Code because I'm not a tax attorney or a CPA. I can give you guidelines, but I'm not going to tell you whether it's a principal residence. Another is if it's a transfer pursuant to a foreclosure or a deed in lieu of foreclosure. Another, if it's a transfer by a governmental agency, that would be your Fannie Mae, Freddie Mac who took title under a foreclosure, or VA or FHA, something like that. Another is if it's a transfer for zero consideration. So that is your deed from husband and wife, a gift deed where nobody's paying anything. You do a quitclaim deed to add your spouse to title. That would not be subject to non-resident withholding, even if neither party lived in West Virginia, because there's zero consideration. And another exemption that West Virginia has that many states don't is for a relocation transaction. So if it is a qualified relocation transaction, the individual, the record owner, is not subject to West Virginia non-resident withholding, even if they've already become a resident of the state to which they were being relocated. Okay. If you don't qualify for one of those exemptions, you can obtain a certificate of exemption issued by the tax commission. That requires the filing of an application, and it can be a certificate for full or partial exemption. So if you have more than one owner and one qualifies for an exemption and the other doesn't, then you can get an exemption from that owner's portion of the proceeds. Okay, the turnaround time for that approval is at least 21 days prior to closing. So as you can see, that has some lead time. And if your seller does not qualify for one of the other exemptions, you're going to want to get them together and make sure that they are aware that they can file for this exemption. If they don't file for the exemption or qualify for an exemption in anything, then we have to withhold. Withholding is either at 2.5% of the net proceeds. That's after you take off the mortgages and the liens against that property and the cost of sale, your real estate commissions, your transfer taxes, things like that. Or it can be 6.5% of the estimated capital gain. Either event, there is a form to fill out for the record owner to fill out or the seller to fill out. If the seller paid more for the property than they're selling it for, then they can fill out the form for the estimated capital gain and end up owing zero withholding. So that's why I bring up that option, is because depending on the circumstances of the seller and how much of a mortgage they do or don't have on the property, even if they would otherwise be subject to withholding, if their capital gain is going to be zero or negative, then they wouldn't be subject to an actual dollar amount withholding. Any questions on the West Virginia non-resident withholding?
I do have a question, Kim.
Yeah.
When we do the withholding calculation, let's just say we're only going to, excuse me, net $10,000, so you take 2.5% of that. That helps them know what they're going to be charged at the closing table. How do they go about getting that back in lieu of talking to their tax person? They just file a one-page tax form?
We provide them. There is a form that they can file that is a request for early refund form. And if we had to collect a withholding and have them file a withholding return at settlement, we normally provide them with a blank one of those forms, just as a courtesy. So, and that comes with its own instructions and things like that. So they would be able to fill out that form and then submit it for an early refund of the withholding tax or whatever portion of it they're not actually subject to. So if they didn't get their application for a certificate of exemption filed in time to have that back prior to closing, we would have to withhold the tax, but then they can file this form to request an early refund. They don't have to wait until the end of the tax year to request a refund of the withholding taxes that were sent to the state.
All right, thank you. And based on our neighboring states, we're pretty inexpensive compared to others.
That is correct. The neighboring states charge a much higher percentage of the net proceeds when it comes to calculating their withholdings. So yes, West Virginia is very reasonable in that regard. You know, if you have a seller that's complaining about the withholding tax, tell them they're lucky they're not in Maryland. Any other questions on the West Virginia non-resident withholding? Okay. Then we go to the FIRPTA, or Foreign Investment in Real Property Tax Act. This is the federal version. There are also exemptions on the federal side. A U.S. citizen is exempt from this withholding tax, as is a green card holder. And there is a list of a way of determining other individual taxpayers who might also qualify for this exemption in the federal code. So if you have somebody who's not a U.S. citizen and not a green card holder, they're probably going to want to be talking to the settlement attorney early on to figure out whether they qualify for this other exemption of U.S. taxpayers, or whether there is going to have to be withholding. As with the West Virginia non-resident withholding, they can also get a withholding certificate. They have to file a form with the IRS, and that has a 90-day to 3-month turnaround time. So that is huge. If you have a seller who does not qualify as exempt from FIRPTA, the moment you list their property, I would suggest that you recommend that they begin the process to obtain a certificate if they feel they're eligible. Or at least start looking into it, because it's a 90-day to 3-month turnaround time. And the reason this is critical is because the withholding calculation on a FIRPTA is 15% of the amount paid. FIRPTA defines the amount paid as the gross sales price, not the net after you've paid off the mortgage and taken off your realtor fees and all that, and the transfer taxes and stuff. It is the sales price. So it's pretty steep. So therefore, if you have an individual who is not exempt and does not get a withholding certificate, they need to be prepared, because 15% of the sales price can be pretty steep, especially if they're paying off a mortgage and other closing costs on top of it. Okay, that was just a real brief on FIRPTA, but enough hopefully to make you aware that paying attention to FIRPTA is critical. Any other questions about FIRPTA?
Of course, I have one on FIRPTA. Why wouldn't I? How can a person purchase as a foreign investor in the United States? What do they have to do to even purchase in the first place?
Well, for the most part, most foreign investors who are not exempt would purchase cash. I mean, there's nothing preventing them from purchasing the property. Now, if they're going to get a loan on it, that would be another matter, because then we'd have to look at whether or not the entity is over here, filed over here, can be bound in U.S. courts, things like that. So if they're getting a loan or something, but if they're paying cash, there's nothing to prevent them from paying cash and taking title to a property. And then, you know, at that point, they would then be subject to the withholding on the other end. There are individuals who do not fall into any of these exemptions who have also bought property in the U.S. with a loan. I mean, they might be in on a temporary work visa, but not a green card. Things like that. I had a transaction several years ago where the sellers were residents of New Zealand, and dealing with FERPTA was extremely tricky because it was also a short sale transaction, which meant there was no money to withhold, but they didn't qualify for an exemption. So we're talking about withholding certificates and timing and getting short sale approvals that were long enough out that it would allow for the completion of their withholding certificate application. So, you know, like I said, if you don't have somebody who qualifies under the exemptions, the sooner you get them in contact with the settlement attorney so that we can start working through things, the better. Any other questions on FERPTA? Okay, then we're going to talk briefly about 1031 exchanges because I want to make you aware of who, what, where, and when in the process attention needs to be paid if the transaction is going to be involving a 1031 exchange. I wanted to point out the 1031, it's a tax deferred exchange, not a tax exempt exchange. It just means that somebody is taking a transaction that would have otherwise been taxable at the time of the transaction with respect to capital gains or whatever, and pushing that tax obligation down the road to a time when theoretically they're in a lower tax bracket or something like that. And that's when they would then be obligated to pay the taxes that they've deferred. So the first thing I'm going to talk about is a qualified intermediary. All right. What is it required, and when in the process should one be identified? A qualified intermediary is a company that has been designated by IRS to take or to escrow the cash from one property to another during a 1031 exchange. So the intermediary, qualified intermediary, is required to be approved by IRS and should be identified as early in the process as possible. If you're working with an investor who is buying a property, fixing it up, selling it, buying another property, and he thinks he might want to be involved in a 1031 tax deferred exchange, that would be the time to identify a qualified intermediary or to refer them to get him or her in the start of the process so that they can understand what is required when and don't lose the tax deferral because they missed a deadline or missed a document. You have two different types of properties. You have a qualified acquisition property and a qualified replacement property. Okay, qualified acquisition property is a property that you're getting with your 1031 exchange money. It's a property you're acquiring, you're going to hold on to, you're going to flip, you're going to whatever. And the IRS has a list of requirements as to the type of property, you know, real property versus investment property, etc. So that's something, again, your qualified intermediary can help you go through. And then a qualified replacement property, if you already own a property and you're selling it, then the replacement property is the property that you acquire in place of the one you're just selling. Now, with the time of contract, there are certain addendums that have to be executed by all parties, and there are certain deadlines and timing that is critical. Because if you miss a deadline or you don't time it right, then it can it can take that transaction, and basically it no longer qualifies for a 1031 tax deferred exchange, and the party would owe the taxes at that time. Net proceeds are dispersed to the qualified intermediary, not to the seller. Refunds are dispersed to the qualified intermediary. If it's a 1031 purchase or acquisition, the funds come from the qualified intermediary, not from the buyer. So all of that has to be worked out with the qualified intermediary, and they need to be involved as soon as you know that's what you want. Any other questions on tax 31 exchanges? Okay. I'm going to go through some of this stuff real quick because we're running short on time. Short sales, obviously, you're going to want an attorney involved. You're going to have attorney's fees to process it. You're going to have approvals required. Turnaround times vary by lender or creditor. And if the seller also has an IRS lien, that is a totally separate application process, in addition to whatever lenders or creditors you're working with. If you do have a short sale, I don't anticipate as many of them as we've had in years past, but if you do have a short sale, keep in mind that HOA companies, any judgment creditors, anything like that, if you got a first, second, and third mortgage, everybody has to be on the same page with regard to who gets how much in order to proceed to closing. So the more loans you have on a property, the more difficult it is to get a short sale through. HAMP loans, forbearances, and loan modifications. One of the first questions is to ask your seller. A lot of sellers are not aware that when they had their mortgage reworked when they were in trouble, that it created an additional obligation or an obligation that got tacked onto the back of their mortgage or something. So when you're listing a property, I would ask your seller. So that way, when you're doing your estimates of nets and whatnot, your seller doesn't end up not aware that he's not going to get as much money as he thought to go buy the next house. Also, whether or not the seller has any paperwork or contact information for those programs. Another thing is all parties are going to need photo identification. One is to comply with the Patriot Act. So even if a seller has granted a power of attorney and is not going to be at closing, we still need a photo ID to comply with the Patriot Act, because we have to have a document that has their name, their photo, their date of birth, things like that. It needs to be, if they don't have an unexpired government issued photo ID with their date of birth, you need to start talking to your settlement attorney to find out what other options are available. There are ways to ID somebody that will allow the title underwriter, that will allow title insurance to be issued, but we need to go through those tracks. Also, name changes. If your seller has changed their name since they recorded their deed, we need to, in addition to knowing what their name was on the deed, we need their current name as it appears on that photo ID, and we need to document the name change. Divorce decrees, marriage certificates, court orders, whatever it may be. Mine, when I got my US ID, I had to have birth certificate, divorce decree from my first husband, or marriage certificate to my first husband, divorce decree from my first husband, and marriage certificate to my second husband to document all of my name changes. So if there has been a name change since they went on title, make them aware that they're going to need to be able to provide documents to show that name change from what it was to what it is currently on their photo ID. Okay. Any other questions? All right. And if you think of something later, there's my contact info. And I'll be happy to try and address any questions you have that might come up at a later point in time. So thank you all for attending and for your questions, and have a wonderful evening.
Thank you, Kim. We certainly appreciate all the great information that you provided. And I'm sure the attendees and members will feel the same way. We are recording this, so hopefully we can get it up on our YouTube page.
That sounds great. I look forward to it.
Thanks, everybody. Have a great evening.
Thank you.
Have a great evening.
Appreciate it.